Okay, good afternoon, everybody. I hope you enjoyed that lunch and the conversation that went with it, following an animated first two panels. This third panel, even though it's right after lunch, where people tend to relax, is going to be even more animated. I've been introduced in the papers concerning this as a professor of human rights, which is quite true, affiliated with Gentle Global University, which is quite true, but there are two other credentials that I need to reveal in full disclosure. One is that I was involved in a transition that involved transitional justice, and that was in Cambodia, where the transition was based upon an agreement among all the parties before anything began. And the justice part, as you certainly read in the press last week, has been extremely slow. It took 16 years to get 2 convictions, and there may be some lessons to learn from that. Second full disclosure is that I'm also, I support numerous human rights organizations, but one of them is called Cultural Survival, that is devoted to promoting and defending the rights of indigenous peoples, which gives me a particular interest in this case, about which I have very limited knowledge. I've never been to the region and hope to go someday. Before we hear from our speakers, who are going to be in a slightly different order than that appears in your program, there's a brief observation that I want to make, 2 brief observations really. These are our panelists, and those are their topics, and I'm going to come back to them one by one. I wanted to start by saying if we want to learn about human rights in Manipur, we need to look at the principal source of information for most of the people of the world. They go to Google, and what's the first thing they find in Google? Wikipedia. And what do you find in Wikipedia? An article on human rights in Manipur. And guess what? Take 30 seconds to read that. I've obviously highlighted in red what should be self-evident. So, normally, articles that have a clear bias to them have a disclaimer at the beginning. This article does say reference needed in 1 or 2 places. It does not say this article appears to lack a balanced approach and we welcome editings to do that. So if we don't change the situation of the Manipurian people here, at least some of the people in this room should become engaged in the editing of this article, unless you agree with everything this article says. The rest of it follows the same spirit. So concrete outcome number 1, edit the Wikipedia article on human rights abuses in Manipur. The abuses referred to here, of course, are those by the insurgent groups, and it goes on to explain that they also employ child soldiers and so on. So if those are the abuses in Manipur, fine, leave the article as it is. Second observation, we have alluded to many outcomes of human rights procedures. Just to anchor them in our minds, this is the reference that was made several times to the July statement of 2 special rapporteurs, simply to clarify who they were and what they said. The special rapporteur on summary executions and the special rapporteur on human rights defenders concluded, among other things, that India has an obligation to ensure prompt, effective, and thorough investigations of all allegations, and failure to do so is a violation of its international obligations. In the same framework, the third cycle of the Universal Periodic Review did not address the numerous papers that were submitted on Manipur. The only thing that I could find of direct relevance was a recommendation of Peru to deepen the respect for the principles of proportionality and necessity for armed forces and police, and by Switzerland to revise the Armed Forces Special Powers Act to bring it into compliance with the obligations of the ICCPR in fighting impunity. And in the response of the Indian government, I didn't want to add a different slide for that, but recommendation 96 was accepted, and 97 was noted, which is a polite way of saying go to hell, excuse me, polite way of saying rejected. So this is where the international scrutiny stands with its strengths and its weaknesses. The temporary conclusion that I've reached from our two panels earlier, and I'm going to call upon the panel number 3 to consider this, is that we may not be dealing with an authentic situation of transitional justice, where typically you have an adequate political will to move forward on finding the paths towards a truth commission, a reconciliation commission, compensation, and so on, and you work out the details on the basis, in the example that I gave of my own experience, the Paris Agreement on a peace in Cambodia, but more on combating impunity. And the principal reference document here that I would like to draw your attention to, that was not referred to previously, are the revised UN Principles for the Protection and Promotion of Human Rights through Action to Combat Impunity, which defines impunity as the impossibility to bring perpetrators of violations to account. Well, from everything we've heard this morning, that's pretty much what we're dealing with, isn't it? The Supreme Court is addressing precisely that problem of impunity. And it calls for the principles of impunity create the obligations of states to investigate violations and to hold accountable through criminal responsibility, through prosecutions and punishment and effective remedies and reparation, those who are responsible for the massive violations of human rights. So the set of principles there can be grouped into 3 parts, and this is what I'm going to conclude with. There's the right to know, and that's what we've been talking about. Now, the right to know doesn't necessarily require a situation like we had in South Africa, right? Or in the other examples that you've given of truth and reconciliation commissions. The right to justice, and that's the jurisdictional problem that is complicated, that is currently before the Supreme Court of India. But there are also options. There are options outside of India. You're not going to get the Security Council to submit India to the ICC, but you could perhaps get some senior official of the Indian government directly responsible to be subjected to universal jurisdiction. At least that's something to explore. And third, of course, is the right to reparation. That's what we've been talking about in the previous panels, and this panel will talk about. So on the question of these principles, there's a book that just came out that commits the grave sin, I think, and it's too bad Shiv is not here, but a grave sin of perhaps reflecting Anglo-Saxon law. I haven't read it. I've just become aware of it. It's called the United Nations Principles to Combat Impunity, a commentary, and it's a big, thick OUP publication commenting on each of the articles of the UN Principles of 2005. And I would, if you're going to accept that there's any value for what was called in the previous panel Anglo-Saxon law, and I would challenge that because I think there is a value in drawing upon a range of traditions to see that the needs of and aspirations of affected populations are met, and if that's done through procedures that some people put in a big legal book published by Oxford University Press, that's fine, but it doesn't diminish the value that this could have for the victim population. So that would be if you're going to take my point seriously, that we're better off pursuing combating impunity rather than assuming we're already at the stage of transitional justice, then I would suggest that this might be relevant. So in order to address the various issues at hand and these observations regarding impunity versus transitional justice can be completely disregarded, but it gives me great pleasure to give the floor to our first panelist, Satman Bains, who is the director of the Punjab Documentation and Advocacy Project, and he will discuss the role of documentation in acknowledging truth in post-conflict societies.